It is 11:15, and I am Pepper Crutcher. I'm the outgoing chairman of the Labor and Employment Practice Group at the Federalist Society. Yesterday afternoon, I was talking to our French friend, Francois Brouillard, and after relating some recent difficulties, he said to me, "But I remain alive and French." My sorrow is that I'm the outgoing chairman of the Labor and Employment Practice Group, but my joy is that for the third year in a row, we are fortunate to have Sixth Circuit Judge Chad Riedler as our moderator of this panel. Judge Riedler earned his undergraduate and law degrees from the University of Michigan. Will somebody please beat Ohio State? Thank you. After graduating, he served as a law clerk to Judge Alan Norris of the United States Court of Appeals for the Sixth Circuit. Judge Riedler then began practicing law in Columbus office of the international law firm Jones Day. Spent 10 years as a partner in the firm's appeals practice group. While at Jones Day, Judge Riedler appeared in state and federal trial and appellate courts around the country, most frequently in the Supreme Court of Ohio and the Sixth Circuit. Judge Riedler successfully argued before the United States Supreme Court in McQuiggan v. Perkins on behalf of an inmate claiming actual innocence. If any of you read the criminal reports, that's an uphill. His other pro bono representations include representing capital defendants before the 10th Circuit and the Supreme Court of Ohio, as well as representing defendants sentenced to life in prison before the Sixth Circuit. While at Jones Day, Judge Riedler traveled to Nairobi with Lawyers Without Borders to train Kenyan lawyers in prosecuting domestic violence cases, and he also was a recipient of the American Marshall Memorial Fellowship, awarded by the German Marshall Fund of the United States. Following his career in private practice, Judge Riedler served as an acting assistant attorney general for the Civil Division of the United States Department of Justice from 2017 to 2019. In that role, Judge Riedler led and supervised over 1,000 lawyers in the United States and federal courts across the country, including high-profile cases with significance to the administration of the department. In March 2019, Judge Riedler was confirmed to serve in his present capacity as a judge of the Sixth Circuit Court of Appeals. He resides in Columbus. Judge Riedler.
Thank you very much. It was a generous introduction. I'm a little embarrassed because the ones I prepared for the panelists are much shorter. So that is not judicial supremacy. That's just, I want to get to the actual conversation. But I hope everyone's having a great Federal Society conference convention. This is one of my favorite weeks of the year, and my voice is a little grovelly, so I have that to prove how much fun that I've had over the last few days. I hope it's the same for all of you. It's great to see so many old friends, but also to make new ones. And I hope we're all back together again next year. So our panel this morning is on agency decision-making, and our three speakers have all served in very high-ranking positions at various agencies across the federal government. We're going to start with some opening remarks, and then I'll have some questions, and hopefully, we don't have a mic, but it looks like the room is small enough, so if we have time at the end, we can maybe take a few questions. Let me introduce our speakers. I'll start here at the table and then move down the row. Vicki Lipnick served 2 terms as a commissioner on the EEOC, including as acting chair from 2017 to 2019. During the Bush administration, she served as the Assistant Secretary of Labor for Employment Standards and is currently a partner at the consulting firm Resolution Economics. Tammy McCutcheon served as administrator of the Wage and Hour Division at the U.S. Department of Labor during the Bush administration. She's also worked as a partner at Littler and as a senior counsel at the Hershey Corporation. And my notes say you're now enjoying semi-retirement, but so I hope you're also enjoying the non-retirement part. Thank you for coming to be with us. And then Seema Nanda served as the Solicitor of Labor from 2021 to 2025, where she previously also had served as Chief of Staff to the Secretary. From 2018 to 2020, she was the Chief Executive Officer of the Democratic National Committee, and she's currently a fellow at Harvard Law School's Center for Labor. So again, thanks to all of you. I don't know if we had a speaking order that we started off with. Anyone volunteers or?
I'm happy.
Perfect.
Good morning, everyone, and thanks so much, Judge, for the nice introduction, and many thanks to the Federalist Society for inviting me to be here. And I will second that it's nice to see people that I've known over the years and many different jobs, and everyone in their positions, and it's a pleasure to be with you, and especially a pleasure to be on a panel with Tammy and Seema. And Tammy and I were colleagues during the George W. Bush administration at the Department of Labor when Tammy was the head of Wage and Hour and I was the assistant secretary. So we have lots of yes, war stories, right, related to that. I'm going to talk about, though, happy to comment on labor, but both Tammy and Seema have that covered well, just to give you a little sense of the EEOC. And I know we have at least one other, an EEOC person in the room. And so, so I did want to just give you a sense of sort of my comparison, I will say, between having been at the Labor Department as an assistant secretary and then at the EEOC, which is a commission. And so, you know, very different in terms of agency decision making. At a cabinet agency, right? Everyone reports up to the secretary, and there's a whole, you know, policy making apparatus there, and lots of engagement with the solicitor's office. The commission is a 5-member commission. It is currently a 3-member commission. At the beginning of President Trump's second term, there were 3 members of the commission, 2 holdovers from President Biden's administration, and President Trump fired 2 of the Democratic members. Some of that is in litigation right now, as are, you know, many of the agencies that have ongoing litigation about members who have been removed. The EEOC, but the principal difference when I got to the EEOC as compared to the Department of Labor is you have to negotiate everything at the commission, because the only way the commission can act in terms of policy making is by votes, and you need a quorum, and you need at least 3 votes in your favor. And having served as the acting chair, you spend a lot of time negotiating with your colleagues, and the entire time that I was on the commission until the very end in at the end of 2019 into 2020, I was the either sole Republican or maybe there were 2 Republicans, but I was always in the minority, even when I was serving as the chair, which is very different than the situation in Trump 2.0. So there's just a lot of having to take into account, you know, different perspectives, and you are trying to get votes for whatever the policy making is you want to do at the commission. Also, the governance model at the EEOC is a strong chair governance model, so nothing goes before the commission unless the chair puts it in front of the commission. The commission has authority to have public hearings on things. The commission doesn't have public hearings unless the chair wants the commission to have a hearing about something. So that governance model makes a big difference in terms of what actions the commission will act on. But again, as I said, even when I was serving as chair, I was in the minority voting, so that always presented some challenges. And then the other thing I wanted to mention is the relationship between the commission, 5-member voting body, or as now a 3-member voting body, 2 Republicans and 1 Democratic member, and the General Counsel's office of the commission. And by statute, the General Counsel's office and the General Counsel, who is also appointed by the President and confirmed by the Senate, the General Counsel's authority in the statute is to litigate the cases, not to initiate what gets brought into federal court in the first place, but for the fact that in the 1990s, when Gil Casillas was the chairman of the commission under President Bill Clinton, the commission voted on and has had in place ever since then a delegation of authority from the commission, which by statute is supposed to be determining what gets filed in federal court, delegated much of that authority to the General Counsel's office so that the General Counsel oftentimes is filing cases except in certain circumstances that the commission either hasn't seen, and when I say commission, I do mean the commission members, the commission hasn't seen or they haven't approved. That was my experience. So when I was at the commission, as soon as I got there, when I looked at this delegation, I was like, who gives away their authority like this? And shouldn't the commission bring back some of this authority to the commission itself in terms of approving litigation? There are some things that are specifically the commission reserved for itself. So the filing of any amicus briefs have to be approved by the full commission, by vote of the commission. Certain types of litigation, if it's big systemic litigation, if it presents a novel issue of law, those are supposed to come to the commission. I felt like I was oftentimes debating with the General Counsel's office, well, you filed that brief, but boy, to me, that sure looks like a novel issue of law that should have come to the commission. However, the commission would have decided. So in my time at the very end of the commission, when Janet Dillon was chair after 2019 and into President Trump's late into President Trump's first term, the commission revised that delegation. Given that the General Counsel's office, and this has been for at least a decade, files less than 120 cases in federal court every year, and the commission has 53 offices across the country. I will say that is in stark contrast to when, during the Bush administration, when Eric Dryban served as General Counsel, and the General Counsel's office was filing 400 cases in federal court every year. I always felt like that function of filing cases in federal court, more of that authority and more of that review should be done by the full commission and voted on by the full commission. I would oftentimes find employers, when I'd go out speaking, say to me, we're being sued by, you guys about such and such. How could you do this? And of course, employers are always outraged, right, by whatever they're getting sued about. But, I would have to say, well, we didn't see it, right? It was approved by the General Counsel's office. So, and the General Counsel's office, in terms of both what it litigates, how it litigates, and in particular, certainly for amicus briefs, makes real policy determinations, which is why I thought more of that authority should be with the full commission. I'll stop there.
Thank you.
All right. I guess this is on. So one of the questions that we were asked to address today in this panel is whether agency lawyers act as neutral legal advisors or quasi-policymakers. Now, I think that answer is pretty darn clear. In my experience at DOL, attorneys in the national office here in D.C., they see themselves primarily as policymakers and as legal advisors only secondarily when they have to. The more interesting question to me is whether they should. My perspective on this question is formed by my experience as an in-house counsel for the Hershey Company. Yes, sweetest job I ever had. I know, go ahead. Followed immediately as a Senate-confirmed agency head at DOL. So first, let's talk about the role of in-house counsel. A private sector general counsel does not run the company. That is for the CEO. The CEO sets the company's strategic direction and makes the major corporate decisions. The job of the GC is to advise the CEO on the legal risk that those decisions present, and if necessary, suggest alternatives with less legal risk. But the CEO is the one who decides how much legal risk to take. No decision, by the way, is without legal risk. We all know that. So think Apple Maps. The CEO enters the destination, and the GC finds the best route to get to that destination. The GC does not or should not put up artificial roadblocks unless the direction the CEO wishes to go will take the whole company over a legal cliff. And frankly, if I had at Hershey always said no, 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 can't, what would happen? I would stop getting asked, right? You just don't get asked. And that's the worst thing to happen, is you never get asked. Now, this relationship between the principal and the attorney is what I expected to find at DOL when I arrived. Naive me. It was not. So I was confirmed by the Senate. The administrator of the Wage and Hour Division actually is a position created by Congress in the original 1938 enactment of the FLSA. Look at Section 4. And that is a policy position. It has the power to issue, for example, opinion letters, which have the effect of, if you get one as an employer, of protecting you completely from liability for FLSA violations. So I was confirmed to set policy. I was confirmed to set the strategic direction of the division, regulations, sub-regulatory guidance, enforcement priorities. Now, of course, the labor solicitor plays an important role in advising the secretary and the agency heads on the legal risks of policy decisions. But agency attorneys really should resist the temptation of presenting their policy preferences as legally required. And there lies the problem. It happens. It happened to me. Story time. So my team had drafted an opinion letter, which I, and only I, have the statutory authority to sign. A career attorney told us there was no legal support for the opinion I wanted to issue. In fact, provided a memo on that with a bunch of cases that were cited. Now, we thought it was a bit weird because it is the position I wanted to take. My staff, career staff at Wage and Hour, has said that's how they've been enforcing the law for decades. Luckily, I had a great deputy, Eric Dryband. You may have heard of him. Later, GC of the EEOC, and also, of course, Assistant Attorney General for Civil Rights at DOJ. And he knew how to use Westlaw. So he pulled and read every case. None of them were relevant. None of them even cited the FLSA. And he did his own research beyond that, and he found an appellate court decision taking the exact position that I had written in this opinion letter and wanted to issue. Now, in 3 separate meetings, we gave the career attorney multiple opportunities to reveal this case to us. We tried to pull it out of him. In the end, he did not. Finally, I had to ask, are you lying or incompetent? I felt there was no other option. So, and of course, there were no consequences to this attorney at all. He continued to be at the Department of Labor until he retired much later. He didn't want to issue the opinion letter that I wanted to issue. So he presented his policy preferences as a legal certainty. So in this one anecdote, it's not an isolated incident, in my opinion, and I believe it is pervasive at DOL and throughout other agencies in the government, especially in Trump administrations. Resist is the call of the deep state, and this is how agency attorneys resist. And political appointees need to be on their guard. So what if we had not been lawyers? What if we didn't know how to use Westlaw and able to do the research ourselves? How many times have agency agency lawyers succeeded in overruling policymakers, Senate-confirmed policymakers, by misrepresenting the legal landscape. Agency lawyers are not policymakers, and they should stay in their line, giving advice, politically neutral advice about the current state of the law and what that says about the policy that the secretary or the agency head wants to put out there. So, I also, not only about policy, but I also heard things from DOL attorneys about how the unions would react, how the press would react, and this is okay, how the Ninth Circuit would, they kept telling me, oh, the Ninth Circuit is going to reverse this opinion letter. By the way, the Ninth Circuit adopted the opinion letter, the Ninth Circuit. So, of course, we also had public and media relations experts who knew far more about how the public and the media would react than the attorneys in the solicitor's office. If you want to make policy, get a policy-making job. They're different. So Justice Barrett, in her comments Thursday night and in her new book, has talked about the importance of humility for lawyers. Also on Thursday, early in the day, Tennessee Solicitor General Matt Rice cautioned us on the danger of relying too much on the expert class. Now, he was talking about medical experts, cloaking their activism as science. But I suggest it also applies to attorneys without humility who see themselves as experts of everything and cloak their policy preference, their activism, as legally required results, prohibiting the administration's policies from being implemented. And I think this is true especially after Loper Bright. Agency attorneys need to get some humility. They need to understand that the courts will no longer view them as experts and act accordingly. Thank you.
So first, thank you so much for having me. I've appreciated some invitations from the Federalist Society, and it's good to talk to all. So I appreciate that. I don't want to get too spicy too early, but I'm wondering, Tammy, where your solicitor was in all of this, who is a political appointee?
He was, and they did nothing. And
okay.
So I am not going to give them a pass. Okay. I'm not going to name names, though.
Yeah, I'm just curious because there is a political. There are several politicals in the solicitor's office. So I thought I'd start my remarks maybe filling in a little bit about my very convoluted and unlikely resume, but because I wanted to talk a little bit about the NLRB and to have a little bit of credibility since it was on part of the agenda today. And I do think it's an important part of the conversation. And so I spent over 9 years at the National Labor Relations Board. And I was there from November of 2000 until early 2010. So the vast majority, and I was a career attorney in the Division of Advice. And the Division of Advice is under the General Counsel's office and does kind of works up cases that come in from the regions, either because they're a General Counsel priority or they're a novel issue of law, or there's something interesting about the case. So it's a little bit more of, your nerdy people who want to, read cases and dive deep into the law. But most of my tenure at the NLRB was working for Republican General Counsels. I worked under Arthur Rosenfeld and Ron Meisberg for most of my time there. I mean, eight of those years were all under Republican General Counsels. And actually then even after President Obama won the election, it was before we fired the General Counsel. So we had another year. And I am going to agree with Tammy on one principle that she has articulated. I saw our role, particularly in advice, was to give the General Counsel, the full the full analysis of all of the cases, and then also give him our best advice, which sometimes he took and sometimes he didn't, as to what to do in a particular advice case. And I took that role very seriously. And having spent 12 years as a career lawyer in the federal government, I've worked at 3 agencies, Department of Justice as a career lawyer, the NLRB, and at the Department of Labor, where I was not a career lawyer. I was political in all my roles, but I've worked very closely with career lawyers who certainly didn't always agree with me or our administration. That is my general sense. And I think you can always find stories, and the reason I wanted to ask Tammy that follow-up question is because in my experience, that is when my clients, who were Tammy, the head of the Wage and Hour Division, and the head of OSHA would come to, or the head of the Employee Benefit Security Administration would come to me and say, hey, our lawyers are not letting us do like fill in the blank. And so, sometimes it would go to another political on my staff or someone else in the front office, and we kind of work through what are we doing here. So I do think, that just to say there's a lot of perspectives, but I haven't found this sort of lack of objectivity, although, you can find an example for all sorts of things. Just a little bit, I thought it was nice for Vicki to ground us in the EEOC, because when we're talking about these 3 agencies, as this panel suggests, they work really differently. And I haven't worked at the EEOC. I hope to one day to fill out like my quad of agencies. No, I actually don't. But not because I don't think you're wonderful, but the general counsel and the board relationship is really different than the EEOC and the commissioner relationship, because, as you all know, the NLRB is the board is actually the adjudicative body, the first sort of appellate adjudicative body, and the general counsel. I think the most significant thing about the general counsel position is that because there is no private right of action, a case doesn't get to an ALJ, it doesn't go anywhere unless the general counsel brings that case to the board and maybe the circuit courts and on for adjudication. And I will say, in my years at the board, and mostly in advice, I did some details and board side and other places. But in my years in advice, that was a really important concept. And that was an important concept for Republican general counsels as well, because there are a lot of issues of law that are not resolved, or advice wouldn't be in business. But there are a lot of issues, and there's certainly a lot of issues that go back and forth, and we can debate the policy around, but there's a lot of important, and how to apply the facts to those cases. So I do think that's an important responsibility, and I think it's important and different than the EEOC, where litigants do have private rights of action, and it's sort of like a, go here first type of statute. The solicitor of labor, and Roger, whenever I've spoken to Roger's audiences, he always asks me to do this, but he's like, no one knows what the solicitor of labor is. No one really knows what you do. So I will, heed Roger's advice and, just give a minute about what the solicitor's office does. So the solicitor is the general counsel of the Labor Department. So like other agencies, the solicitor does everything a general counsel's office does. So it advises on appropriations, it advises on shutdown. Like, may I please forget everything I ever learned about shutdown, but I feel for them because it's a painful process. But it's advising about all the internal things like the general counsel of a company. And the solicitor is working very, very closely with agencies on rulemaking. It varies. Some agencies don't have any rulemaking staff, really. So the solicitor's office is holding the pen, and some, it's a very back and forth relationship, sort of filling in the law and writing together. But the main thing that really makes the solicitor's office different than other cabinet agencies is for the vast majority of the laws that DOL enforces, and there's, if you count all the regulations, there's over 150 laws. The solicitor is directly enforcing the law, and that could be before administrative law judges. It could be in district court. It could be in various tribunals that the solicitor's office is litigating the cases, and often also appearing in the circuit courts and doing the injunctive work. And that aspect of it really makes it different. And so in some instances, there's, like at the National Labor Relations Board, in some instances, there's no private right of action. And in some instances, there is a private right of action. So in terms of this question of, this provocative question that's in this title, like, should agency lawyers be policymakers, or how much are they policymakers? I found it very interesting. I mean, it's, certainly something that has come up because, sometimes at an agency, people are like, you're just the lawyers, But I will say this. I always try to have, seeing whatever role you're in, like, be in that role, right? Like, okay, now my job is to be the political head lawyer at this agency. So I saw my clients were people like Tammy, the heads of all of the sub-agencies at DOL, as well as the secretary. Those are my clients. And on things like, what are we do? The agency wants to issue this field bulletin, or the agency wants to take this risk in a rule. I do think in those situations, your role as lawyers is really to, give your best advice, but really work hard to get your client where they want to go. I mean, I think there is a general proposition that if you're a lawyer in any context who's like, no, people are like, all right, who else can I talk to? So, I mean, you try to get your client where they want to go if you can, in a principled way. But at the same time, I also think that in the litigation context, because these agencies are so deeply under-resourced, what you choose to litigate is policy. So I tried to err on the side of transparency about that, and to speak to audiences of workers, work unions, worker representatives, employers. I never turned down a single invitation I had to speak, because I think it's important to bring transparency to these offices. And we did not have the resources to litigate the vast majority of litigation-worthy cases. And what we choose to litigate, I would tell people what my criteria was. Is it impactful? Is there a private right of action? Is there another way to resolve this? Are we trying to resolve a larger problem? Are we trying to sort of do something that is going to get at some broader issue? I would look at issues like that as a lens where we had discretion. I mean, in some cases, if you don't have discretion, you don't have discretion. But I think we tried to do that with our clients. But I do think, being the political head of an agency, it's kind of a political job. And I think you should try to have those good relationships with your clients, but you are, in a quasi-policymaking role.
I wonder if we might want to go back. I wonder if we might want to go back down the road just to see if there's any comments to some of the commentary you've heard so far. I saw you taking notes, so I thought maybe there was a few.
And then my pen ran out of ink.
Oh,
so
well, here we have
I'm okay. Just a couple things. So in terms of what Tammy was saying about Tammy and Seema, in terms of when the policymakers, right, which are oftentimes the folks, as like Tammy, the position Tammy was in, or I was in at Labor, where you are in a policymaking role. I do think that oftentimes for the political appointees, you do have to be prepared to say no, or you have to be prepared to say, well, no, this is what we're going to do in the face of whatever advice you have been given. As Tammy said, she had the experience of, okay, well, and this was always the case with Tammy, though, to her credit, right? We're doing our own legal research. But you have to recognize, and this is not a partisan thing, Republican or Democrat, in terms of who's running the agency in the political positions. You just have to recognize that the agencies are completely mission driven, right? The folks who've been there for decades, and you're passing through for 4 years, maybe, or maybe more than that, and so they are so focused on the mission of the agency that sometimes they lose that perspective. And part of your job as the political policymakers is to be a check on that, right? And so you have to know what's the agenda, of course, that you're trying to accomplish. And I appreciate what Seema was saying in terms of being very transparent about it. But you do have to recognize how mission-driven, whether it's a cabinet agency or a quasi-independent agency like the EEOC can be, and you have to be prepared to be a check on that.
I think I might have liked Seema as my solicitor of labor better than the one I was talking about.
I'm gonna print that and just carry it around with me, Tammy.
No. The really issue when the attorneys step over the bounds on policymaking, and transparency is key, right? Tell me why you think that this legal landscape means I should adopt this policy rather than this policy. Don't tell me I must adopt this policy with legal advice that is not good, right? So that is really what bothered me. And I was lucky that I could do my own legal research, but it really wasn't what I should have been doing. And that one incident, which was very early on, I must say, the issue there is this was the head FLSA lawyer, the career head FLSA lawyer, who I totally lost trust in. And that's what happens, I think, when you get out of your lane, when attorneys do, is you lose trust. And just like the CEO who's going to stop listening to their general counsel, I stopped listening. And whether that was good or bad, and by the way, everybody, I'm a bit of a bull in the china shop. I know it. There was the peacekeeper right over there between me and the solicitor's office. And I actually think that it will change because, as we know, we have Keith Sonderling is now DepSec, and he started in wage and hour. I don't know if he was at EEOC, of course, but before that, he was a special assistant in wage and hour. He, I know, felt the same frustrations in Trump 1 as I felt in Bush in this solicitor's office versus wage and hour back and forth battle. And I trust Jonathan Berry, also just confirmed and just sworn in on Wednesday as solicitor. So I think we're talking about new legal frontiers. I think there will be a new frontier at the Wage and Hour Division and DOL in general because Keith Sonderling is doing such an amazing job over at DOL.
The only thing I'll add is I don't know how you all got Westlaw passwords because we tried to really keep a tight grip on those. But I will say almost all of my clients, agency heads, were lawyers, and not just lawyers, like really expert lawyers in their fields more than I do. So I think a lot of this is just, are you coming from a place of respect about what each of you are bringing, to the role and having conversations about what your interests are. I know that DOJ isn't represented other than, of course, the judge and my years at DOJ. But one thing that's really interesting and with the Department of Justice is they really, the agencies, right, are the clients then of the Department of Justice and, are defending our rules for the most part and defending the agency in some other context. But they really don't see themselves as in this role of having to listen to their clients. I mean, they're very much, we are the Department of Justice. We have our institutional interests, which is always kind of interesting to me. So I would reflect on that and some of the things, conversations we'd have with DOJ, like, gosh, they really need to be a little bit more client-oriented and try to sort of bring that frame when I was sort of dealing with my clients.
Maybe you were there in the wrong administration. So I was acting head of the civil division. I thought we did our best to work with all of our clients as well as possible. DOJ, of course, has the ultimate responsibility to make legal determinations. So I'm going to actually use that as a jumping off point for a question. I'll try to use, I know we have a lot of different agencies here represented, so I'll try to ask general questions that can apply across the board. But so the EEOC and NLRB have independent litigating authority, I think up until the Supreme Court.
Yes.
And then labor has some independent litigating authority, but then DOJ also comes in at different points in time. So how does, in the different roles, how does the thought that at some point, DOJ could come in and change positions or have a different position on the decision you've made, does that impact your decision making or processing at all?
So at the Labor Department, by and large, for the statutes we were enforcing, we had pretty independent litigating authority where we would need DOJ approval. DOJ just historically litigates the LMRDA cases, so we would work up the case and send it to the Department of Justice. So then they take it, if they accept it, they take it for litigation. But otherwise, in the situations where we needed authority at the front end, which is mostly in the ERISA context, that is all done at the front end. So in my experience, it wasn't that DOJ comes in later and takes over a case or takes positions. I think the question, usually the conversations with DOJ would come in about whether we're going to appeal a case, whether a case is a good vehicle. And I think like any lawyers who litigate cases, you get invested. And I think there's always a tendency of the agency lawyers who've worked on the case for years and, the agency has probably investigated the case too, have a more, tendency to want to appeal the case. But I didn't find it to be, none of these were adversarial relationships. I think they're more about orientation. And I think there's a different orientation at the Department of Justice. I mean, I think it probably transcends this in administrations, although I don't know right now, given the decimation that has happened at these agencies. But DOJ has a real institutional interest and things that they really care deeply about. And I think it transcends administration. So they're always looking out for those things, although we'll see if that starts to change too.
One of the things I'll just mention is that at DOL, the ultimate choice for litigation is with the solicitor, right? The Wage and Hour Division will decide whether they want to, they used to, go to the solicitor and present a case for, this is the case we'd like to litigate. More and more in recent years, however, the solicitor's office has intruded itself into actual wage and hour investigations so much now that they actually send an attorney into each and every final conference, which used to be the conference between the employer and the wage and hour investigator. Not even the district director, nobody. But, and my experience, because I've been to those meetings, is that it really, really slows down the settlement. So we don't get a choice, right? The ultimate decision to when to litigate is the solicitor's office. But I did find out that if the solicitor's office gets cited by a court for frivolousness and there's fees, it comes out of wage and hour budget. I always, at least it did mine. So I was always
We would never do that.
I would.
Can I ask?
just-
The EEOC has. I don't know if you're able to answer for the EEOC, because they have independent authority. When I was at DOJ, we had a very high-profile case in the Second Circuit en banc where the EEOC had taken one position litigating the case. The DOJ submitted an amicus brief taking the opposite position. I thought only in the government can you have two positions.
Right.
And then when it went to the Supreme Court, the DOJ position won out, didn't win out actually in the Supreme Court. But so I'd love to hear thoughts about that.
Yeah, so my experience in terms of working with the Justice Department when I was running the agency as the acting chair, sort of two experiences. One, kind of what Seema was saying. So there was a matter that DOJ was representing the agency. The agency had gotten sued over a certain policy issue, and DOJ was representing us. And I was not happy with that representation. I mean, I really wanted them to be more zealously taking on the defense of the agency that would have ultimately preserved more of the agency's policymaking. And I felt like, boy, the institutional interests of the DOJ litigators was so much more, we're trying to preserve our reputation in front of this judge. We're trying to preserve, DOJ's position. And I was like, I'm trying to win this case. So there was that aspect. And then I was at the EEOC that was the decade of really moving cases for representing LGBTQ individuals and trying to get a case to the Supreme Court. And so, and that was it literally started when I first got to the commission in 2010. So the back and forth with the Solicitor General's office on that brief in particular, that was a discussion about should we take this case to the Supreme Court. And your original question was, well, how does it influence, your thoughts about working with DOJ from the agency's perspective? And there was a real genuine debate among the career staff who had been working on these cases for a decade of, oh gosh, now remember, this is, in Trump 1.0, we really don't want DOJ to take our case, right? They're not going to litigate the position that we want. And that ultimately became the Bostock case in the Supreme Court. But there was a lot of consideration about, is DOJ going to argue what we want them to argue? And so it was, we were very engaged on that.
Yeah. I hate that the unifying theme is that DOJ is dropping the ball as lawyers, but in any event, so there's so much going on right now in the spaces that you all have worked in. I don't know if I want to ask you any specific sort of policy or legal question. I could think of a number. Seema mentioned kind of the, you could say, overhaul or turmoil in the executive branch and reduction of employees at different agencies, including lawyers. At DOL, of course, there's been some discussion about counting jobs and how that process goes and if it's reliable anymore. So do any of you have thoughts on, are there any hot button question that you want to offer thoughts on, legal, political, otherwise?
Well, I want to, I'll think about that. I have a lot to say, but I'm thinking what's constructive. I will say, to a point that Tammy made about early involvement, I will say, I think, at least in the Obama and the Biden administrations, it was a very intentional effort to have early involvement of lawyers in cases. And I would submit that that's actually good for the regulated community, because a lot of times it's that, this case doesn't have teeth. But also, I think it's important to remember that these are worker protective statutes that all of these agencies are enforcing. And so to the extent that we're doing our jobs at DOL, unlike at the NLRB, but this is the case at the EOC too, when the investigators are not the lawyers, or on that same team. I mean, the investigators are in the client agencies. You don't want to get to the end of the investigation and have the client really frustrated because the investigation isn't sufficient to support litigation in the eyes of the solicitor, because they spent a lot of time on it, but they didn't get what the solicitor's office needed, and so the case isn't going to have legs. And I think that's when you get frustrated clients. So it's actually it can be an intentional strategy to say, let's get in early, let's see what our clients are doing, and work through the cases. And it's also a good strategy for figuring out what you're going to litigate, because there's nothing more frustrating to a client, and particularly given, it's worse now. We were deeply under-resourced, but I think at DOL, they've lost another 25% or so of people. So that's a lot for already a deeply under-resourced agency. So when your client is working up all these cases and is like, go litigate all these cases, you're like, I can pick one this month. And that's really frustrating. Whereas if you've been kind of working towards that, this is going to settle, you can make better decisions. So it is a strategy. And I think, the last thing I'll say before we get to maybe the spicier question you pose is, thinking Tammy's reflections and about the frustration with agency lawyers, and I think, Vicki, your way of putting it, these people really care about the mission, and they're very dedicated to the laws that they're enforcing. I thought that was a nice way to put it. I mean, I think there's a lot of fealty to the statutes and what people are able, their deep expertise in them, and how they think that they should be enforced to protect workers appropriately and do fealty to the law is my experience. And I do think the reality is, in Republican administrations, the vast majority of political people who come in have not represented workers. And they don't come from that background. They come from more of what I think is a management background. And I do think that does create this dynamic that there was some, they're not with us. And I'm not saying at the agency we're sort of protecting workers in some way that they're our clients, but we are their worker protective statutes that are being enforced on behalf of the American people. And I do think that might create some more tensions between the political folks who come in and career staff. But I will tell you, we had our tension points too.
I'm going to defend Republican administrations. If you look at the actual numbers at wage and hour, back wages collected, employees helped, Republican administrations, Trump 1, Bush, we do better than Democratic administrations. You can go online, you can get it in the budget documents. I keep a Excel spreadsheet, and on a budget dollar for dollar basis, Republicans do better because we're just enforcing the basic law. There are so many violations out there of basic minimum wage and overtime laws that it's a cornucopia, right? What happens is that because they're trying to push policy through enforcement and litigation, they're out there, top-down management. So I listened to my field employees. You tell me what you think the violations are, and that's where we're going to go. Instead of top-down, we have to go about independent contractors who love to be independent contractors and don't want to be employees. And so we're going to waste our time doing all these independent contractors. And that's my answer to your question. I think right now the hottest issue is the flip-flopping of the DOL based on the political administrations on independent contracting. The Trump administration passed some regulations. Biden withdrew those and passed new regulations. Now the Trump 2 has reissued the proposed regulations and is enforcing the Trump regulations and not the Biden administrations. Can they do that? I don't know, but that's what they're doing. And I think with Loper Bright, it's going to be very, very interesting to see how courts deal with this every 4-year flip-flopping on an issue that affects, so many millions and millions and millions of people in this country.
Judge, I wonder if I could ask you a question related to what Tammy said. So when an agency changes its position, right, and so now and of course everybody sues over everything now, right? So it's going to be litigated.
I will note that my 2004 changes to the overtime regulations, nobody sued.
Absolutely true, Tammy. So if the agency changes its position, and then one, sort of how you think about that generally, and then two, when all of the amicus briefs come pouring in and saying, look at this 40-year history of all these things where the agency has had this prior position, and they can cite every kind of, whether it's a regulation or sub-regulatory document. And I'm just curious about generally how you think about that when that situation comes to you.
Yeah, sure. I'm going to just barely leave my role as moderator and then go very quickly back to it. But on the amicus brief point, I will say the Supreme Court gets overwhelmed with amicus briefs. I think that's true in every case. They get dozens and dozens. The appeals courts don't. If we get 1 or 2 amicus briefs, that's quite a few. So I'm not discouraging amicus briefs. I actually find them quite helpful, and we don't see them all that often. On sort of your history and change of position point, I will just say I just issued an opinion this past week about Thrive remedies from the NLRB, where I'm just going to quote what's in the opinion, but that was sort of a position that I view that had sort of changed from kind of 90 years of practice of having a more narrow view of what remedies the NLRB could order to a broader view that was taken a few years ago. A number of circuits have weighed in. There's some split over the issue, but if you read the opinion, I think we said we're at least a little bit skeptical that if you look back over history, that the agency's practice had been different than the authority it asserted in 2023. But other judges have disagreed on that, so it probably depends on the judge you're asking. But so I'm going to go back to you. Did you do anything sort of current day issues that are kind of top of mind, or you think are worth discussing?
Well, one thing related to what Tammy said, I am curious, sort of in the post-Loper Bright world, right? How again, given that everything gets challenged now, it doesn't matter who does it, right? It doesn't matter what administration. And so I'm just wondering what the debates are going to be in the litigation about, is this statute ambiguous or not? And who's going to be, arguing that position and trying to preserve, whatever position the agency has taken. So I guess we will see how all this plays out.
Yeah, why don't we use that? I'd love to. So Seema, you were in office when Loper Bright came out. So did that sort of immediately change your decision making? And if so, how? And Tammy, if you want to weigh in, or anyone else wants to weigh in on that question.
I think for Loper Bright, I think for years, the writing was kind of on the wall that Chevron deference was going away. So you would not, you'd be loath to, you'll find some, but you probably saw this judge, the administration hadn't been citing Chevron for quite some time. But I actually found Jarkissi to be a much more remarkable decision than Loper Bright, because I feel like Loper Bright just sort of put it in writing. I'm not saying it's not significant, but it felt like it had the agencies had kind of been planning on it. I do think, I'll say a word about Jarkissi, but just on this Loper Bright question, I think the question to me is how much regulatory work does anybody want to do in light of the challenges and in light of Loper Bright, and how much resources do you want to put in, and how do you go about them? The independent contractor rule, I could talk for an hour, as Roger knows, about independent contractor, but the thing I will say on independent contractor is we weren't going to do rulemaking, but we were sued on our rescission of a rule that had already been struck down that we thought was not in compliance with the law. And so in that decision, striking down our rescission because it failed to go through our rescission. We did a straight rescission rule, and our rescission of the rule was struck down for failing to really wrestle with should there be another rule. So, we really felt like the court is telling us, like, do a rule. So, I will say, I sometimes in administrations, I do think there's this question, is it better just to litigate than, and because the law and what you litigate does shape the law as we are seeing. And I think that's a real question after Loper Bright. Just on adjudicacy, I do think this question of, if we go down this road of, looking at every statute and when can you get civil penalties, unlike in the SEC context, a lot of these worker protective statutes do not have an option to go to district court, which you did have in the adjudicacy decision. And so I think this question of will that be implied that you can go to district court? Or are we just going to say we're fine with worker protective statutes that really have no, aren't as Congress intended anymore? What happens to all of those laws as these cases make their way through the courts, I think is an interesting question. On this question of, what is the most significant thing happening? There's so much, but I will say, in the spirit of the panel that we are on, I think what is happening with civil rights laws under our country and just an absolute focus on, these, what reverse discrimination cases, which I know is not a term people say, but to sort of break it down as sort of an exclusive focus of what our nation's civil rights laws will focus on, as well as attacks on diversity and equity and inclusion that clearly go well beyond anything about those that are legally unlawful. I think that is probably one of the most significant things happening in this space right now. I know Jonathan just got there, and I'm hopeful, and to the point, your sort of defense of Republican administrations. That wasn't my point. That there aren't worker protective things that happen in Republican administrations. I was sort of going back to the tension point, I guess you sort of identified early on was the point I was trying to make.
I think you're right that there'll be rulemaking will be more hesitant, and it will be a lot more work. And there's going to be a lot of long preambles to the regulations, because you're going to and also it's because of the litigation world now. Like I said, in 2004, when we issued our Part 541 regulations, there was no lawsuit. And except for the salary level, those regulations are still unchanged today. But I think you're writing your legal brief in that preamble now, and wanting to make sure it will withstand litigation and be persuasive to the courts. The one Supreme Court decision that I think is actually more impactful at the Wage and Hour Division was the Encino Motor Cars decision. Right? And that is where the Supreme Court turned around this idea that you had to interpret exemptions and exceptions to the FLSA rules narrowly, and that was wiped off the board, and the Supreme Court said you have to interpret everything in the FLSA on the same playing field. Now, I will say after that decision, you started seeing Encino cited in every single opinion letter. That was Keith Sonderling, by the way. Thank him. And I think from a enforcement policy perspective, that decision should be and was hugely impactful on how the enforcement of exemptions and exceptions from overtime and minimum wage pay requirements have been applied by the Wage and Hour Division.
One thing I was going to add, in terms of doing rulemakings, and as both Seema and Tammy said, I mean, if you are at an agency and you are doing a major rulemaking, and like Tammy referred to the Part 541 regulations under the FLSA, those are a major rulemaking at an agency, and this is pre-Loper Bright. It is at least a 2.5-year process, just because of all the information you have to gather, and it's not just looking at all the case law, but then you've got to do all of the economic analysis that goes along with it. And so I do worry or wonder, right, how hesitant agencies will be to take on those kinds of projects, and I'm really interested to see what the courts do in terms of, when rulemakings are completed, and I've said this 3 times now, because everybody gets sued over everything now. So no matter what rule is that you put out, there's going to be some challenge to it, and how interested the courts are in taking that on. I had the experience at the EOC. We did a rule and under a statute that, Roger, you will remember this, and related to wellness regulations, and the court said, we want to see that entire administrative record. Well, this had taken years, right, for the agency to put together that administrative record, have the experts, and then the court saying, oh, well, we think, you could have done a little bit more here or there. Like, seriously? So I'm interested to see how the courts really deal with all of this rulemaking in the post-Loper Bright world.
Well, and I'll say one more thing. If the agents, I prefer rulemaking to sub-regulatory guidance.
Sure.
I think it's more transparent to the public. If we're going to set rules, it's got to be in a context where the regulated community knows how to find them. How many people know how to find the opinion letter on whether mortgage loan officers are exempt? And I'm wondering whether if there's hesitancy, which I think all 3 of us think that there might be, how will that affect the sub-regulatory guidance? Are we going to see more sub-regulatory guidance because it's just too hard and too risky to do regulations? And I'd love to hear both of your views on that.
Well, one thing I will say just generally in terms of sub-regulatory guidance, and, I'm sure we've all had this experience, is even when you complete the regulation, right, because a lot of, you get pressure, hey, you need to fix these regulations on such and such when you're the policymaker. So, you go through your 2.5-year process and you do it and you think you fixed it, and then you hear from the regulated community that, well, that wasn't what we wanted. But there is this immediate demand then for sub-regulatory guidance, right? Because everybody wants the regulations to be the complete contingent claims contract, and that you have answered every one of their compliance questions. When you're the in-house counsel at, Hershey, and, you want to know, what do I do about this situation? Because we are a compliance nation, there is such a demand for sub-regulatory guidance, but I think agencies certainly will hesitate on that now.
Thinking back to my confirmation hearing and my meeting with Senate staffers, I felt like I was like, yes, we will not issue inappropriate sub-regulatory guidance. Everyone was obsessed with this sub-regulatory guidance issue about, whether you were going to do things without notice and comment rulemaking. And I definitely have Vicki's experience. When you do put a rule out, people are like, what does this say? Can someone please issue sub-regulatory guidance? And even on things that people don't want a rule, they want sub-regulatory guidance because they want guidance to help them, and it can be a compliance assistance tool. So I just think it's sometimes regulatory guidance can really be a helpful way for the regulated community to really understand what the rules of the road are, and and how to comply with them. And it can be written in a much more plain language way than, sadly, rules are often written. I mean, when we'd have these weekends of having to read rules, we're like, how many pages? What do you got? Like 450? Okay. I mean, it was, it's brutal even for us as government regulators writing them. We don't want to write them like this. But I will say, there's sub-regulatory guidance that really shouldn't be. It should be done with notice and comment rulemaking, and that is the lawful way to do it. And I think that is really important. One of the issues with the independent contractor position that I have with this administration is we followed the rule, the Trump rule after that decision we got, striking down our rescission until we issued a new rule. And so there is a rule on the books that has not been struck down. And why isn't this administration following it? I mean, that is violating notice and comment rulemaking on something that at least the Trump 1 administration thought was subject to notice and comment rulemaking. So, I think you have to look, very carefully at it when you're talking about sub-regulatory guidance and what's appropriate and what's not.
So we've talked a bit about agency structure, the role of lawyers in agencies, and one of you provided me with some statistics that surprised me a little bit. It seems that DOL and EEOC have about 500 lawyers each working in the agencies. The NLRB has about 700. There's been a lot of talk about, obviously, restructuring government, downsizing government for different reasons, efficiency reasons, and other things. I guess I just ask you, do you think any of these agencies are right-sized, too large, too small, and maybe specifically to the number of lawyers working in all these agencies? Are we at the right number, or should that change?
I'll give a surprising answer. I would like to see more wage and hour investigators, and Vicki will tell you, I've always thought that.
Yes.
I advocated for it back in Bush, that we needed more investigators. Just because I'm sorry, guys, there's a lot of really bad violations out there. We had like a Chinese buffet style restaurant owner walk the employees and their back wage checks to the bank, made them cash them, and then took back the money. Right. So there's that sort of thing out there. And so I think there needs to be more investigators. And I also think that I have no problem with the number of lawyers who are actually doing the litigation, who are out in the field all over the country, who are actually litigating cases. My concern about too many attorneys, and that this was me, and it was Google AI, so, but there's like 35,000 lawyers in the federal government only, and 10,000 of those are in the Justice Department. So I guess my question is, how many lawyers are not necessary? I think it's something we should look at. How many lawyers are actually out there doing the litigation, actually out there directly enforcing, and how many are sitting in national offices or regional offices managing? And how many management levels, and are those really necessary? Anyway.
I will say it's really wonderful to hear you say wage and hour needs more investigators. Tammy, I was with Jessica Luman, the wage and hour administrator in the Biden administration yesterday, and she gave a statistic that was really startling about there were historically low numbers of investigators in the Biden administration, but I think they've lost another 200 or so. So I think it's 600 or something. The statistic she had was essentially we have about $1.50 of enforcement dollars going to covered American workers in the wage and hour division, which is a startling statistic. I mean, I will say my view is all of these agencies agencies are grossly underfunded, and that goes for all enforcement. And enforcement, I think, includes investigators and lawyers. They're historically at lows. The mission keeps going up, and the number of lawyers keeps going down. I think it's very hard to look at an abstract number of, it's like, unless you know what people do, it's hard to say, what is an abstract number of government lawyers. But I will say it's, they're big, complicated places. But I will say for, I was with a practitioner, a practitioner before the NLRB, and she was saying in upstate New York, some of the regions have 2 people in the entire field office, have 5. I mean, there are cases sitting for years, and that's not justice for anyone. We were so decimated in our field in litigation in the Biden administration, and with our numbers steadily going down, flat funded in the solicitor's office for going on 15 years with little infusions here and there that have sort of kept the decimation, the total decimation. But there's a lot of picking and okay, well, we can't really litigate this case that our client wants to litigate. So what are we going to litigate? How are we going to try to handle this problem? And I think, one thing is really thinking about fealty to the laws. If Congress passes laws that have a scheme for enforcement, I think we should be able to enforce them and trust federal agencies to enforce them at the levels that they really need to be enforced. But all of these agencies are at historic lows right now.
I would just say whether the agency should be right-sized or not, the fact is that's the budget reality now. So I just, I don't think we're going to get any major resources poured into any of these enforcement agencies. And certainly at the EOC, the majority of the lawyers are in the field actually litigating cases. They're real litigators. They have pretty high workloads, and you see it, in terms of the numbers of cases that actually get filed in federal court. But that is our budget reality.
Great. I think we're about out of time, so please join me in thanking our terrific speakers.